Wow, this Dragonlance lawsuit is crazy. Margaret Weiss and Tracy Hickman suing Wizards of the Coast. I wish a lawyer who had a background in both 1980s to 1990s D&D and contracts disputes could run this down for me. Wait a minute. Margaret Weiss and Tracy Hickman has sued Wizards of the Coast in excess of $10 million. This suit stems from a contract that Wizards had with Weiss and Hickman for the development of new Dragonlance materials, namely a book trilogy set in the Dragonlance campaign setting. This is probably the biggest lawsuit regarding Dungeons & Dragons since the 1980s. Hi, I'm Legal Kimchi, a licensed attorney who works on contracts for a living, and this is some DM good gaming. So yeah, it's kind of hard for me to talk about how important Dragonlance was in the 80s and 90s for Dungeons & Dragons. We seem to think that the Forgotten Realms is the default and preeminent setting, but that wasn't the case. Dragonlance was D&D for a time, and for the most part, Weiss and Hickman were Dragonlance. Dragons of Autumn Twilight was the second non-kids book I ever read, behind the Crystal Shard. Weiss and Hickman, however, don't own the intellectual property for Dragonlance. This may seem weird, but it's actually pretty normal with regards to these types of things. Most engineers who create things for a company don't own their innovations. The company does. It's part of what the company pays for when they pay creative workers. Whatever product is produced, the company owns. While I will discuss the details of the case as they are currently known, I will use common attorney parlance, namely allegedly and it depends. We don't know any of the real facts of the case at this time. A lot of it depends on the language in the contract, which I have not read. But I have read a lot of contracts. A lot. Like a lot. Like it's my job to do. But we can glean a lot from looking at the petition. Oh, one thing of note. I'm licensed in the state of Texas, so we refer to the complaint as a petition. This case is based in Washington state law, so there may be some differences to the interpretation of the law. The petition sets out a set of alleged facts that support the plaintiffs, in this case Weiss and Hickman's, reason for filing suit. They detail their version of events, of what transpired between them and Wizards. According to the petition, Weiss and Hickman came to Wizards to discuss revitalizing the Dragonlance setting for 5th edition. Specifically, they proposed writing a new trilogy of books set in the Dragonlance campaign setting. As mentioned before, Weiss and Hickman need Wizards' okay to publish these books, as Wizards holds the intellectual property, or IP. In March of 2019, the parties agreed to a new licensing agreement where Weiss and Hickman would write a new trilogy to be published by Penguin Random House. Weiss and Hickman alleged that Wizards was given a full overview of the story that was going to be in the trilogy prior to signing the agreement. According to the plaintiffs, Wizard had a full outline by June, and the publisher, Penguin, approved the first book in the series in November. Here's where the legal notes come in on the facts of the case. Weiss and Hickman state that they will, quote, meet all contractual obligations and receive all requisite approvals from the defendant, end quote. This is a key point in the litigation, and we'll get to that in a moment. They go on to allege that Wizards gave notes for the story to be more diverse and inclusive, and that is a general push for a lot of fiction nowadays. And Weiss and Hickman state that they accommodate those requests. One of the accommodations being a 70-page rewrite in the first novel. This tingles my spider sense, because it seems to be something that Wizards may have put into the contract to ensure that they had the editorial ability to direct the story to where they saw fit. There have been too many high-profile cases of discrimination and racism for Wizards to ignore this issue. One only has to look at Ravenloft, also originally created by Hickman, to see rather stereotypical representations of minorities in past works with the depiction of the Vistani, a culture based on the Romani, a real ethnic group, to see where the concerns would come from. Then, Weiss and Hickman alleged that on August 13th, 2020, on a phone call with Wizards execs and counsel, and Penguin Random House's execs and counsel, Wizards stated that they would not approve any more drafts of the books and that no reasons were given as to why Wizards was not moving forward. They then allege no, quote, material breaches or defaults were indicated or existed upon which to predicate a termination, end quote. See the word material? That has meaning in a court case. After this, there's more flowery language from the plaintiffs speculating on the reason for the termination of the contract. Most of this is pretty meaningless in my opinion. Remember, the petition is where the plaintiffs get to say their side of the story, as biased as they want to paint a picture of them as the victim. This is normal, but everything there should be taken with a grain of salt. Then they go into jurisdiction and venue. Now, this is where it gets really confusing for a layman. So, Weiss is in Wisconsin and Hickman is in Utah. Wizards is called a citizen of Rhode Island, but is a Delaware limited liability company, and Hasbro is also a Rhode Island company. Yet the case is in Washington State, heard in federal court. Weird, right? Well, Wizards is physically in Washington, so their contracts probably state that their court cases will happen in Washington. This is really common in contracts to identify the venue, so people don't have to have lawyers in every state to go take care of their cases. For instance, I am licensed in the state of Texas, but I can't just go to Washington and practice law with my Texas license. I need to go through this whole process of reciprocity to do so. So Wizards has their attorneys in Washington, and they will just use them. Why is Wizards a Delaware company when they're actually in Washington State? Well, you may have noticed that many companies are incorporated in Delaware. This is super common. You may think that this is some sort of tax issue, but it's actually that the corporate laws in Delaware are cutting edge. They're the most sophisticated. Even companies that aren't Delaware companies sometimes stipulate that their contract should be viewed under Delaware laws. With this contract, I'm unsure if they stipulate the laws that govern it. They probably do, and it's probably going to be Delaware or Washington State. Now, this case being in federal court is also significant. When you have two parties from different states in a civil case worth more than $75,000, the federal court can have jurisdiction over it. Why $75,000? Well, that number is arbitrary, and historically it goes up over time. The last time they changed it was sometime in the 1990s. Federal courts are known to be a little bit more sophisticated. They generally have more experienced judges. You're less likely to see crazy high judgment numbers in these courts as well. The plaintiffs then discuss the details of the history of the license, from its origin between TSR and Weiss and Hickman to Wizards' takeover of TSR and thus inheriting the license. Then it goes into the aforementioned controversies involving primarily a writer by the name of Nick Kellman and Orion Black. Now, to be clear, these don't have anything to do with the suit or the allegations directly. What the plaintiff is doing here, or rather their attorneys, is planting the story of why Wizards allegedly breached the contract. The petition goes on to allege that Wizards spoke to Penguin regarding the book with the intent of actively interfering with the plaintiff's business relationship. This is also telling, in my opinion, and we'll get to that in a second. Then, the petition goes on to the actual causes of action. First is breach of contract. This boils down to two things. The plaintiffs are claiming that they have done their part to perform the contract as requested. They are stating the defendants, Wizards, have failed to do their part. Now here's where I really want to read the licensing agreement, because it all hinges on the termination clause. So in most contracts, you have a section for term and termination. The term is how long the contract's supposed to be valid for, in this case, 10 years. The termination clause states under what circumstances that a party in the agreement can terminate or cancel the contract. Most contracts will have one or two sections under that. The first being termination for convenience, and the second being termination for cause. Termination for convenience is pretty simple. It gives one or more parties the ability to cancel the contract for no real reason. Many contracts don't include this in a business-to-business relationship, but some do have it, like your contract with Spotify or the PlayStation Network. You can cancel those at any time. Termination for cause specifically outlines the circumstances that you can terminate a contract for if the other party suddenly gets bought by a terrorist organization, or they dissolve as a legal entity or something. My speculation is that Wizards would have had some termination for cause language in there, perhaps relating to their editorial approval over the works Weiss and Hickman created. If I had to guess, that's going to be their defense. They will say something along the lines of, the plaintiffs drafted something that we didn't like. We attempted in good faith to revise the story to fit to what we wanted it to do. But after Weiss and Hickman returned their rewrites, we understood that we were not making the progress we wanted and decided that Weiss and Hickman were not rewriting their story in good faith. So we terminated. Having something that would require a 70-page rewrite can be seen to indicate that Weiss and Hickman were way off base. And while Weiss and Hickman may have thought that their rewrites fixed the problem, Wizards may have seen that rewrite and lost hope that Weiss and Hickman could ever actually fix the issues. To be clear, this is pure speculation on my part, but I would not be surprised if that was Wizards' response. I'm not actually saying that this was factual or what really happened, but it'll probably be in the response to the complaint, which is called an answer. The next cause of action is the implied duty of good faith. Now this is a weird one. Not that it's included, but that it's hard to tackle because there is no set standard as to what is or is not part of the implied duty of good faith. This is usually included by the plaintiffs to cover themselves if the defendant is found to be within their rights as stated in the contract. Imagine what I said previously was correct about Wizards' argument back at Weiss and Hickman, and that Wizards was fully within their rights to terminate the contract. Then the plaintiffs can respond, yes, but they had an implied duty to work through this with us. This is hard to quantify, and it's different from state to state as to what the standards are for this implied duty. The last cause of action is tortious interference. It basically states that Wizards intentionally caused Weiss and Hickman to breach their, and by their I mean Weiss and Hickman's, contract with Penguin Random House. For this, the plaintiffs have to show that Wizards committed a tort, or wrongful act, that interfered with Weiss and Hickman's contract with Penguin. If Wizards can show that they were within their rights and justified in their termination of the contract, then they did not tortiously interfere with Weiss and Hickman's contract with Penguin. The plaintiffs then asked for $10 million. Where did that number come from? Well, it's a mix of projections and just a nice round number. The truth of the matter is, no one knows what the actual damages are. These are serious allegations, but as with any petition or complaint, this shows the events from the point of view of the plaintiff and holds the defendant in the worst light possible. That being said, most of the time, there are details and discussions that go into the decision making we may be unaware of. Court cases are tricky. Juries are hard to predict, and nothing is really ever as open and shut as we like to think they are. If they were, lawyers wouldn't have much to do. I would love to get more detail, but the facts are not out yet. The next step for Wizards is to answer the complaint with their defenses, but that's going to be just as biased as the petition. The real meat and potatoes comes after that, during discovery. Discovery is where the two parties send requests for productions, for documents to be exchanged, requests for admissions, to get facts admitted to, and interrogatories, to ask questions in writing that they need answers to. Then, on to depositions and witness testimony. All that fun stuff. That being said, I don't believe this will go to trial. Like I said before, court cases are tricky and hard to predict. The certainty of settlement usually reigns supreme. I would expect that Weiss, Hickman, and Wizards get together and settle the case for a substantial sum of money. It'll probably go undisclosed and be held confidential. It may even provide some other caveats to the plaintiff. Maybe even that the Dragonlance IP ownership is given to Weiss and Hickman, though I seriously doubt that. This probably spells the end of Weiss and Hickman's involvement with Wizards of the Coast, and Dragonlance, and Dungeons & Dragons in general. But as weird as this may sound, Wizards may have a new team tackle Dragonlance without Weiss or Hickman. That seems weird to even think about it, but it is possible. There is a large part of me that is sad that this is even happening. I know a lot of older fans would love to revisit this setting. It, more than any other setting for D&D, is actually filled with dragons. On a personal note, I've always felt a little connection with Tanis Half-Elven. He's mixed-raced, not really accepted by humans or elves. As a mixed-race person, I relate to that a lot. I never felt fully accepted by Asians or Hispanic people. Being caught between cultures is a hard feeling to come to terms with. Being a minority is one thing. Being a minority without the support structure of the other people in the minority group because you're not really one of them is even more alienating and isolating. I recorded this video yesterday, even though I have other videos in line that have already been edited and are ready to release, because this is something that I felt touches my personal expertise and connects with me directly. I hope you found it informative. Thanks for watching, folks. Remember to like and share the video, subscribe if you liked it, and hit the bell icon to be notified when more videos are released. Spread the word with your friends. It really helps the channel. If you have questions or suggestions for an upcoming video, comment down below and I may respond in a future video. Let me know if you like me breaking down the legal side of this fun little hobby of ours. And remember, folks, roll dice, roll play, and roll with it.